Today's course is called Virginia Residential Landlord Tenant Law 101. Now, it is specifically, at least from my end, strictly a research project, I guess you might say. We're going to be going through all of the changes that have been made to the law since 2019, with, let me make sure I can get that to do, the caveat that this is a survey. So to the extent that you are needing very, very detailed information, we did attach a copy of the current version of the Act in your materials as an appendix. So at each juncture in the outline, you'll see that we give a specific reference to the statutes. If you need more detail than what's in the outline, please refer to the statute because we have 1 hour to get through 21 changes in the law. I will mention something else is we are not covering anything that happened in 2021, but there is a very good reason for that. All of the major legislation dealing with the Virginia Residential Landlord Tenant Act was carried over to an anticipated special session to be held later this year. That is according to the General Assembly's own website, although to my knowledge, the special session has not actually been called. So if for some reason they don't do that, I don't know if that legislation will be taken up again in 2022, or if it will just have evaporated into nothingness and will have to be reintroduced. So we are limited to the current law based on the amendments in the past 2 sessions before 2021. Oh, I see Mr. Steele Sr. is online. So what will Okay, sorry for blasting people with that. I didn't realize my volume was turned up quite so high. I hope yours wasn't either. So changes, yes, we've had quite an unprecedented amount of change. So let's get right into it with the 2019 session, a long delayed revision to the Virginia Residential Landlord Tenant Act that turned into a political minefield. Certainly most of you know that in 2019, for the first time in 2 decades, the Democratic Party had control of both the legislature and the executive mansion. And Governor Northam had specifically campaigned on, among other issues, revisions to the Virginia landlord tenant laws, which were viewed by some as too favorable to property owners. I try not to get too political in these presentations, but I think sometimes it might slip through. So if you have an alternative viewpoint, please feel free to make a comment, ask a question, and using chat to do that. I'm going to go ahead and repost here real quickly both the links to the outline itself and also to the PowerPoint presentation, so that if you did not get those earlier, you will be able to. And also remind you again, please, if you would, oh, did I send that to just one person? No, I sent it to everybody. To send your name and bar number through chat as a backup, or if you're on an audio only line, to send it by email. And also, if you happen to be using a shared device, make sure that you let us know that and who all is watching on that one device. All right, so let's get moving into the actual substance here. Depending on where you lived in the Commonwealth, there was a wide disparity in how the general district courts enforced the existing law. The changes introduced and ultimately passed were intended to address both of these situations. The extent to which these changes were successful was widely debated, and as we will see, led, that should say led, not lead, to further amendments in 2020. So the really big change, the one that I think a lot of people are still unaware of, is that previously, if you were what they called a mom and pop landlord, if you had fewer than 4 rental units, you were not subject to the Virginia Landlord Tenant Act. That is no longer the case. Mom and pop are now subject to the act. There are certain carve outs in there that we'll talk about that only apply to the more commercial landlord people, but the act now applies to all forms of residential lease agreements, including house sharing arrangements. So if you own a house and you have a roomer, ROOMER, not RUMOR, who stays there under a rent paying agreement, you're subject to the act. And the requirement that you have a written lease that we'll talk about in a minute applies to you. There are also carve outs for those types of situations, but nonetheless, it now applies to every form of residential. Okay, sorry, I skipped ahead too quickly there. Every form of residential landlord tenant situation where the lease is for a month or more. So there are specific exceptions there for short-term rentals, hotels, motels, that sort of thing. But anything for a month or more is you're going to find yourself under the application of the VRLTA under some circumstances. And now the shameless promotion. And we've had our first comment question. This truly is live and interactive. Thank you for that. Does that apply to adult children living and paying rent in their parents' home? Yes, it does. Personal relationships are not an exception. At least I certainly don't remember seeing that in the definitions anywhere. The issue is whether or not they are paying rent. If they're helping out with the expenses, right? They're going to the grocery store and buying the groceries. Maybe if it's not clearly a rental situation, but if the deal is they're living in the basement, mom and dad are living upstairs, and dad expects them to write him a check for $400 or $600 or whatever on the first of every month, and that goes directly into dad's bank account. Yeah, they are a landlord and a tenant under that definition of the house sharing the roomer situation. So thank you for that question. The other big change is the requirement that all residential leases must now be in writing and include specific terms as set out in the statute. If there is no written lease or if any of the required terms is missing, it would be implied by law to govern that relationship between the landlord and the tenant. So the terms that are expected to be required is that the lease is 12 months with no automatic renewal. The rent is paid in 12 monthly payments, not weekly, as is sometimes the case for lower cost rental housing. Rent is due on the first of the month and late after the 5th of the month, so a 5-day grace period. A reasonable late fee may be charged. Now, we're going to talk about a change that happened in 2020 that actually sort of affected that, although it did not eliminate the concept of the reasonable late fee, but it did put some limitations on it. The security deposit can be no more than 2 months rent, and there was a 2020 change that affected that too. So we'll talk about both of those later. If there is no written agreement, or if the written agreement does not include all of these terms, it does not prohibit the landlord and tenant from subsequently entering into a written agreement. So if you have a written agreement and it comports with other aspects of the statute, you can, for example, make a lease for a weekly, week-to-week payment of rental. It's not required that you have these. It's that if you don't have them, they will be implied for you. Now, one of the things that these reforms intended to address was this never-ending cycle of landlords, particularly in low income situations, who were perpetually keeping their tenants on the verge of eviction if they had any delinquency at all on their record. Because as we know, what happens is once you get behind, you tend to stay behind unless you have a windfall that helps you get out of that. And so a favored tactic of landlords was to file an unlawful detainer every single month. And then as they would move through, they would constantly be that close to having the party evicted. They could apply payments and dismiss the older suits, but keep the other ones active. In 2019, we changed that law so that if there is an unpaid rent and the landlord brings an unlawful detainer, for those of you who may not be familiar with that term, that is simply what we call an eviction in Virginia. The landlord can maintain only one unlawful detainer against the tenant at a time. However, the court must allow the suit to be amended if additional rent comes due. So the idea is here we're going to keep only one suit at a time. There's only going to be one set of fees that can be applied to a judgment. It's only going to be one judgment that can be entered. And this hopefully will end some of the abuse of landlords sort of using the unlawful detainer as almost a way of keeping the tenant under eternal threat while using that as sort of their leverage to get the rent payments and the late fees and things out of the tenant. Not that they shouldn't be entitled to do them. Obviously they should be, but to not use it in an abusive way. Under prior law, a landlord was not required to present notice of termination of the tenancy into evidence as an unlawful detainer. I know some of you who are more familiar with landlord-tenant law will say, well, no, wait a minute, what are you talking about? Of course they were required to do it. Well, no, they weren't actually required to do it in order to obtain judgment. Certainly, in most cases, it was ultimately presented into evidence. But now it is required that they make that part of the evidence before they can be granted possession. Under the 2019 amendments, the notice must be presented into evidence. More to the point, and as we shall see, the requirements for proper notice have been changed as well. So landlords who are using boilerplate notices before July 1, 2019, and have not updated them may be in for a rude awakening at their next court appearance. They'll present that boilerplate notice that they used, and they'll suddenly find out that it doesn't contain all of the information that the law now requires, and the court will say, case dismissed. More shameless promotion. So we do have our fall CLE seminar. Most of you that have been with us for a while know that that was sort of how we originally got started. The course lineup is listed. We haven't quite started registration yet, but be on the lookout for that. So go to the website if you want to see what's coming up. So this next section is kind of the longest section here in my part of the presentation, because I think it's probably, in my mind at anyways, the most important aspect of the 2019 legislation. It is just a pilot program, but I think it's one that may prove to be very beneficial and probably be expanded statewide after the end of its trial period next year. If you're not familiar with eviction diversion programs, you know, most people, most lay people at any rate, when they think about homelessness, this is what they envision: somebody mentally ill living in a cardboard box in an urban center. And that's because most of us will never experience the loss of our home to eviction or face a real challenge finding housing. But the truth is, most evictions are against people who are working or who have just recently lost their job. They are considered to be working class poor. And it's about 51 million people. So that's, you know, you can probably figure about somewhere about 17 million families, something like that, if you take the average family size, between 15 and 17 million. And 1/3 of those families are at risk of eviction in any given year. That's a pretty eye-opening statistic to me, that that you're talking about something along the order of 17 million people being faced with homelessness simply because they're unable to make the rent because of circumstances that are very often beyond their control. And what's more, once you have an eviction on your record, you're going to find that it's a lot harder to get a new landlord to undertake you. That information is out there, and they're going to take it into consideration. So you create this sort of that should say unending, or no, I'm sorry, ending the cycle of eviction. Yeah. For many such families, you just have this path where you're constantly trying to find a place that you can afford, that you can stay in, and that you don't face eviction again because of circumstances such as the loss of a job, a sudden medical emergency, that sort of thing. So one approach that has had a significant impact, and it's been tried in quite a few other states besides Virginia, is eviction diversion. In 2019, the General Assembly adopted a pilot program for just 4 urban jurisdictions: Richmond, Petersburg, Hampton, and Danville. They did not include a rural jurisdiction in this, despite the fact that these programs have actually been shown to be much more effective in rural areas where evictions are quite common than necessarily in urban centers. I'm not sure of the politics behind that, whether there was an effort to do it and it was rejected, or whether it was just not considered worthy of trying. That's the same slide, isn't it? I must have hit the wrong button. There we go. Tenants in the 4 jurisdictions whose sole issue is late rent, so it can't be a violation of some other term of the lease, are entitled to participate in the program. They have to request it at their first court hearing. Okay, this is something that they actually have to ask for. They're not going to be sent into it by the court without their requesting it. Once it's requested, however, the participation by the landlord is mandatory. I will say, although the slide does not mention it, this is one of the instances where there is a carve out for mom and pop. It may actually be up there later in the presentation. I can't quite remember, but so this does really only apply to the 4 or more rental unit, the commercial type renters. The program, the goal is to avoid a judgment of possession. And the process actually looks very familiar to those of us who have gone into general district courts, where the judges will sort of informally try and keep someone from being evicted, at least in the initial parts of the process. So essentially, as I mentioned, non-payment of rent has to be the only issue. The tenant has to ask for it on the first return date. Thereafter, the landlord and tenant have to agree on the amount due on the return date. That is the next, at the return date, they have to come up with an understanding of this is how much money you currently owe. And then on or before the return date, that is the next return date, the tenant has to have paid the landlord or the court at least 25% of the amount due. Going forward from there, the tenant testifies why, testifies he or she has sufficient funds to make payments, and the tenant testifies why he or she fell behind in the rent. Now, these things are just for the court's information purposes. There's not a special, like you can't say, you don't have to say it's because I lost my job or it's because I had a medical expense, but you do have to give the court a reasonable explanation. I'm not sure what the court could do if you said, well, I used it to pay for my trip to Disney World. I think the court might take that somewhat askance, but the purpose of that informational hearing is not to determine whether or not you can participate in the program. You are entitled to participate in the program, but you do have to testify to that. In the past 12 months, you cannot have been late in rent more than 2 times in any 6-month period, or more than 3 times in a 12-month period to be eligible for the program. You can't have used the right of redemption in the last 6 months, something we'll talk about a little later if you're not familiar with that term, and you cannot have participated in the program in the last 12 months. So once a year is all you get. The tenant can realistically meet the obligations set by the court. Okay, if you truly are not going to be able to make even a token payment, 25% of the rent that's due, you're probably not going to want to be in this program anyway. But as I mentioned, the court is not making a value judgment as to the reason tenant fell behind in rent or whether the tenant is a good risk. The presumption is that the tenant has the desire to avoid eviction and simply needs time and consideration. Studies where this has been done in other states have shown that where the tenant is unable to meet the obligations of the diversion programs, landlords actually obtain possession of the property sooner than if they had followed a standard eviction procedure, because the diversion program is sort of a one-shot deal. If you don't make it, that's essentially a confession that you are not able to meet your obligations, and the court will award possession. You're not going to be able to say, all right, I want to go out of the program and now go in and challenge the unlawful detainer on some other grounds or try and work out a deal, or no redemption. You're going to get rid of possession. Now, of course, that doesn't necessarily mean the landlord will take possession of the property and evict the tenant, but if they want to, it actually benefits them to be in the program. The success rate for the program, very high, both from tenants who have been able to stay in their location, in their residences, and landlords who don't have the same type of legal costs or the cost of reletting the property. So it's actually a win-win situation when it works, and it has a very high success rate. More shameless promotion. So I started using these little videos in the ethics course that we put on in March and earlier this month. And a number of people commented they like them because it just gives them a sort of a palate cleanser between topics. They can stop thinking about the previous one and think about the next one. But we are going to have our organizational meeting in Harrisonburg 2021, October 21 to 24. Information on the website, registration starting soon. We are looking for volunteers to help out with some of the planning. Oh, somebody says, could you please send me the slideshow? I have the written materials, but not the slideshow. That's okay. So the person who sent me that email, let me post the links again. If you have access to chat, you can download the slideshow. If not, I will try to remember to send that out to everybody in the confirmation email. We did not use the PowerPoint presentations to get the CLE credit, so they're not required material for you to have under the rules, but I do appreciate that most people probably would like to have them. So I apologize if you're not able to get them through chat, and I will try to make sure that they get out to everybody today. So getting back to our presentation, fee shifting is, of course, an issue that is not just limited to landlord-tenant law, and there's been a lot of talk about this lately about whether or not the American rule needs to be reformed in more cases, especially given the fact that the cost of having an attorney is frequently the principal limiting factor in access to justice issues. In landlord-tenant in Virginia especially, it was almost unheard of that a landlord would not be entitled to an award of attorney's fees to enforce a residential lease agreement. And it was virtually unknown that a tenant would ever recover attorney's fees for successfully litigating an issue in court. So you definitely had an imbalance there. But big change here occurred in this respect with one aspect of landlord-tenant law. Where there is a tenant's assertion of poor housing conditions or poor housing conditions are raised as a defense to an unlawful detainer for non-payment of rent, the successful tenant is now entitled to recover attorney's fees by statute. So not in every single case where you successfully defend an unlawful detainer, but specifically where you are alleging that the landlord is not meeting their obligation to provide livable housing. And but those of us who have been around long enough, we know who those landlords are in our areas. And the fact that attorneys can now represent parties and obtain fees when successfully prosecuting these cases, I think is going to make a big difference. So pay to stay, I mentioned earlier, the right of redemption, something that you cannot have used within the last, I believe it's 12 months or possibly 6, if you're going to be in one of those diversion programs. So it's the ability of a tenant to pay back rent and avoid eviction. It's always been available, but the 2019 amendments have expanded and clarified what the tenant's rights are in this regard. So the first chance is simply with any inside any grace period, at least 5 days, if it's not longer. The tenant pays the rent, the tenant gets to stay. They can do this any number of times. It's just, that's part of the contractual arrangement. Oh, let me go. We've got a comment here. Are there any exceptions for landlords who only rent out their basement and can't afford to upkeep the house? All referring to the loss of mom and pop exception. I'm not entirely sure I understand the question. Are you saying the basement is livable, but the rest of the house is not? Or James, can you, that was sent directly to me. Well, they can't keep the whole house up. Okay, because they're a family. I see. Well, let me start by saying one would hope that because they're a family, the the tenant would not be bringing bringing a suit against the parent, and the parent would not be bringing an unlawful detainer. And if they're not actually a family, if you've got a tenant, and I know of situations like this where business owners rent out their basements in their own homes to an employee and that sort of thing. The answer to your question, I think, is there is no carve out for mom and pops with respect to that anymore. And yeah, she mentions this is especially common among immigrant communities. Exactly. But the straightforward answer to your question is that now that mom and pop type rental situations are subject to the law, unless there is a specific carve out in the individual statute saying this only applies to owners of 4 or more, then yeah, it does apply to them. So I think the correct answer to that is if it's a situation where there's likely to be an adversarial relationship, you're going to want to avoid it. In I would think in cases where you've got people who are already living sort of on the edge and they're renting out part of their home to try and make it work, more often than not, at least the situations that I've been involved in, and it's not that many, but I've been involved in a few. It's always been either a family member or a very close friend of the family, and it's never been an issue about adversarial between the landlord and the tenant. It's always been something, either a neighbor who's complaining about occupancy rates or possibly a zoning violation, that sort of thing. But yeah, that's an interesting point to raise, and it may be that if this turns out to be a significant problem for the smaller property owners, the 3 or fewer that are doing that, you may see some revision to that. All of these changes, of course, take a little while to have their impact. They have to sort of draw the attention of the legislature to get it done. We are at our halfway point, so I'm going to go ahead and post the link to our CLE form. I will remind you that if you cannot get this off of chat, you will be getting an email from us later with the CLE form. And if by chance you don't, we will deal with that at the end about how you can get in touch with the VMVLA and make sure that we get this done. I'll also remind everybody, since we are at the halfway point, if you have not done so already and have access to chat, please send your name and bar number to me, John Koehler, host. So we have that as a backup to the Zoom log. If you are on an audio only line or cannot access chat, please send it by email to the VMVLA. Getting back to the right of redemption, the next chance comes after the grace period ends and before the landlord has filed an unlawful detainer eviction suit. So we have a quick question or comment here. Is filing an unlawful detainer submitting the initial letter to the tenant that they must pay, or an eviction will take? No, the filing it means filing it in the court. Filing it in the court. Okay, so before the landlord has filed, if the landlord accepts the rent, then they cannot then file an unlawful detainer saying the person was late, because they've made good and they've accepted. I know that during the second half, James is going to be talking very specifically about this process. And so I'm not going to go into it in any great detail, but there are things that the landlord has to be careful about doing at this point when accepting partial payments or full payment if they're desirous of getting the tenant out because of other problems. Okay, redemption is available under the following circumstances. Usually this is the time during which the landlord has given the tenant a 5-day non-payment notice. If the tenant pays the rent and the late fee during this period, the tenant gets to stay, and they can also do this any number of times again if the landlord accepts. The third chance is after the landlord has filed an unlawful detainer lawsuit and on or before the court date, the return date. This is called a redemption to pay and stay, or a redemption tender, where the tenant makes the offer to pay and stay. And again, James is going to go into this in a great deal more detail than I am. Typically, redemption must bring the tenant current on all obligations to the landlord and to the court, if any. Landlords can accept a partial redemption with a reservation, or the court can postpone a proceeding 10 days to permit the tenant to make a full redemption. Now, what has changed is they added a fourth opportunity for redemption after the writ of possession has been made. Previously, once the court entered that writ of possession, the right of the landlord to evict the tenant with the sheriff's assistance, redemption was no longer possible, at least in a, I guess what I would refer to as a legally enforceable way. You would always have the option if the landlord was willing to sort of forgive and forget and take the money. But as far as a legal right of redemption, there wasn't one. Under the new law, the tenant must proffer the full amount due to all the parties and the courts, the parties including if there is a separate attorney's fee payable directly to the landlord's attorney. It has to be in some certified form of payment, either a cashier's check, certified bank check, or a money order, at least 2 business days before the scheduled date of the eviction. Redemption after legal process has begun can be used only once every 12 months. To be clear, that is one redemption regardless of whether it is proffered before or after the writ of possession is issued, not once before and once after. Evictions have a tremendous emotional impact on tenants. If you've never been present at an eviction, it's not a happy time for anybody. The sheriff's deputies definitely don't like it. Got a comment here. If there was no written lease, when does the 12-month lease requirement kick in? From the date of the law's amendment? That is an interesting question. I believe that is correct. Yeah. So if there was no written lease in place, oh, well, actually, I'm gonna take a step back on that. If what you already had was an existing month to month, because a written lease had been entered into but expired and converted to a month to month, I think it would remain a month to month. If there had never been a written lease, then I think upon the first due date of the rent, which presumably would have been July 1st, since one of the other implied aspects of the law is that rent is due on the first of the month under the implied. Then yes, then it would automatically become by operation of law a 12-month lease. Now that is certainly something that's probably going to be litigated if it comes up. In other words, if somebody tries to claim that because they had an existing non-written lease before July 1st of 2019. However, since the 12-month period from the July to June of 2020 is already passed, unless it actually gets litigated, it probably won't become an issue. Another question, is there a boilerplate lease agreement out there that you recommend? Does any county provide a sample lease agreement that has all the requirements? In answer to the second question, I've never seen one. The government doesn't get into the business of writing contracts for people. James will probably be able to answer that other question better. I will leave it to him whether he wants to chime in now or to wait until his time comes in 23 minutes.
So yeah, I will cover that as part of my presentation.
Okay, so in the next half of the presentation, you'll get an answer to that about I would say model lease rather than boilerplate. I think boilerplate has kind of a negative connotation to it. But anyway, getting back, thank you for those comments again. We do love to keep it interactive. That's what the bar loves. That proves that you all are not just letting the Zoom run while we're chatting on and you're off, doing other work. Heaven forfend. But anyway, I have actually had the misfortune more than once in my life to be unintentionally present to observe an eviction. They are not happy events. Ben Weaver relented when faced with the reality of evicting the Scobies. If you don't know that reference, you ain't a real Southerner, my friend. Look it up. Will Wright, who played the original Ben Weaver, by the way, was also Sergei Rachmaninoff in Rhapsody in Blue with Robert Alda as George Gershwin. Great movie if you've never seen it. And interestingly enough, he was Rob Petrie's father on the Dick Van Dyke Show. In one episode, Rob's father showed up. So all of us old timers out there, we had a nice little walk down memory lane. The rest of you, you can just you can just look it up on Wikipedia. So the consequence of the tendency in human nature was that landlords would frequently hesitate to have a writ of possession executed. Not always for humanitarian reasons. Sometimes they just like to bully their tenants. Prior to 2019, writs were valid for 12 months. The new legislation has reduced it to 6 months. So use it or lose it. Appealing a judgment granting a writ of possession was often difficult to impossible for the tenant because the court was required to impose an appeal bond for the unpaid rent and an amount deemed sufficient to cover the accrued rent during the pendency of the appeal of up to 12 months. Typically it was 3 or 4, but even that would be out of the reach of just about every tenant. If you had that kind of money to begin with, you wouldn't be facing an eviction. So the 2019 amendments reduced the bond requirement to just the money judgment to be paid within 10 days of the order of possession. However, they do have to maintain their rent payments during the appeal in order to keep the landlord at bay. Okay, so I've used up 2/3 of my time going through 1/2 of my material. So I'm going to try and pick up the pace here a little bit. We are in the 2020 amendments. They were actually more extensive than the first. How much more?
Here's a tip you'll appreciate. It pays to have a smile that's bright, to help you look and feel just right.
Double your pleasure, double your fun with double good double mint gum.
Yep, that's right. Twice as many, 14 bills in all, 7 in the first 2019 session, 14 in the 2020. One of the things that they did not get done in 2020 was fair housing reform. Most of the fair housing rules were already in place because of federal law. But it has been a consistent problem in the rental market. And the protected classes you see there in the little graphic were already covered, as I mentioned, by federal law and then by state law, by fiat. But prior to 2020, it was permissible to deny rental housing to a prospective tenant based solely on the source of funds they intended to use to pay their rent. Now, mostly we're talking about some form of government assistance, but also the landlord could say that if parents were going to be co-signers, that they could deny it on that basis, or if the party's principal income was Social Security or even Social Security disability funds, they could say, well, I'm not discriminating because you're disabled. I'm discriminating because I don't think you have the right source of funds. You don't have an adequate stream of income. This is one of the restrictions to which the mom and pop exemption or the former exemption still applies, so to speak. It is a carve out that they're not required to accept people who they think don't have the necessary income stream, or if the source of income is something that they're not comfortable with. If the tenant cannot establish that the source of funds is guaranteed within 15 days of making the application, the landlord may deny it. So simply saying, you know, my mom and dad are gonna help me with the rent. You need a letter or something saying, yes, we're going to provide for this, or better yet, have them be co-signers on the lease. Another reform with respect to eligibility requires landlords to take into consideration the applicant's status as a victim of domestic abuse. I'm sure most of you know that one of the things that keeps victims from moving out is that they often lack their own independent credit worthiness. So when doing a credit check on an applicant who asserts that they've been a victim of domestic abuse, the landlord now must take this into account. And if they don't, if they improperly deny an application on that basis, this is one of the other amendments that has a fee shifting provision. Let's see here. We've got a couple of, or actually just one new question. Would fair housing laws in general apply to mom and pop landlords, i.e. could it be a fair housing violation if parents kicking the child out because they don't approve of the child's religion or family status? I'm going to be 100% honest and say I'm fairly certain the federal laws do not apply to small property owners. I am not sure about the state law, because when they removed the mom and pop exemption, if they didn't specifically add back in a carve out to a specific statute, then by operation of law, it became subject to them. And I can't say for certain, since they didn't amend any of the other fair housing laws. I didn't actually look directly at those. I would almost certainly think that if they had put a carve out, it would have been highlighted. So the likely answer to the question as to the one before is, if a carve out was not put into the statute after the exemption was removed, then yes, those laws do apply. The federal laws I know already had a limitation on smaller landlords. To clarify, is an applicant's, whoops, we got a couple things. Is an applicant's statement that they have suffered domestic violence enough to trigger the law, or the can landlord ask for some additional verification? I think, I don't see there's any reason why they could. I don't think that, however, in other words, the applicant not being able to provide evidence right away, I don't think that would exempt the landlord from taking it into consideration. I would say that in not every case is there going to be a police report or a restraining order. They may in fact be looking for housing in order to get out of the situation, and have not yet done the legally necessary steps to provide that protection. So I'm going to say no. Is there a definition of who is a victim of domestic abuse, and is some documentation required? So basically the same question. In the definitional section that was enacted in 2019, it would not have been in there. Are landlords required to ask about domestic violence? No, the applicant needs to say, I'm not going to be able to establish good credit for this reason. Please take that into consideration. So no, and they're also not required to divulge that if they wish. If they don't want the landlord to know, they just need to be aware that that may result in them not being found to be creditworthy. So as to whether or not the definitional section was amended in 2020 to include a specific definition, I don't think so. I don't recall seeing it. But again, the entire act is available as an appendix in your material, so you would probably want to check that out. Moving on, I hope. Get back online. There we go. Tenants' rights. So here was a big one that got debated in 2019, but got pushed over to 2020, was whether or not we needed a tenant's bill of rights, so to speak. But as of 2020, landlords must offer new and renewing tenants a statement of their rights signed by both parties, a copy of which has to be retained in the rental office. There is, for the person who asked about boilerplate, so can a person without a long-standing credit history claim domestic violence? Is that a good strategy? Well, I wouldn't. You're not saying it under oath, so it's not perjury, but I never think lying is a good strategy. I would definitely have to look at the statute more closely. Because I understand, yeah, you're saying it could be subject to abuse. Somebody just coming in and saying, well, the reason I don't have a good credit history. Are mom and pops exempt from the copy of tenants' rights? Again, I do not know of a carve out in that statute. I could be mistaken, but you do have the text there in the outline. As of 2020, so they have to do this. As somebody asked about boilerplate, you can actually go to the Virginia, excuse me, Department of James may have to help me out on this. I'll get to the consequences of failure in a minute. The State Department of Housing, what's it called? Housing and Urban Development.
Department of Fair Housing, I think, or yeah, something like that.
I thought it was fair housing and something else. But anyway, you go to their website. There's actually a link in the outline, and they have a standard form that you should be used. Somebody said, what's the consequences of failure? Well, we'll get right to that. Proof that the document was provided is a prerequisite to maintaining any legal action against the tenant. And that's what it says. So I'm thinking, the tenant punches you in the nose and you bring a personal injury suit. I don't know that you would need to prove that you gave them the tenant's bill of rights. But for right now, I definitely have a copy of it. But essentially what this means is, if going from July 1st of last year, if you do not have for every tenant a copy of the bill of rights, of the tenant's rights, signed by them and signed by you or your agent, that is an absolute defense to any legal action you bring, and all they have to do is go in and say, I don't recall ever signing this. I'm going to crave order of a copy. And the landlord says, well, I don't have a copy. And the only thing the judge can do is say, case dismissed. Now I would point out that the tenant cannot refuse to sign it. They can't say, oh, I'm not going to sign that, and that way you can't sue me. It's a requirement that they be given it, that they sign it, that the landlord sign it, and they each retain a copy. It's not one of these things where it's optional. Okay. I suppose if a tenant refused to sign it, that would be grounds for voiding the lease, because you do it at the inception of the lease. Are there any legislative updates regarding what exactly it takes to create an informal lease, like if a freeloader pays for groceries or a bill or otherwise helps out? I don't know that that there's any basis for saying that creates an informal lease. If they're not making a regular payment of rent, or there is not some written agreement as to the expenses that they will take care of on a regular basis, I don't think that constitutes a landlord-tenant situation. James may have a different view. Does renewal mean signing a new lease simply, or letting a lease continue from month to month? It is that. Okay. So I have a 12-month lease that automatically converts to month, that let's say runs out before June 30th of this year. So let's say next month is when I start my month to month. Because it was done before the tenants' rights legislation, I didn't sign that when I got into it. But when my 12-month term ends, the landlord has to go and say, okay, unless you want to renegotiate a year's lease, you're going to convert to month starting on May 1st. And I need you to sign this document. I'm going to sign it. I'm going to give you a copy, and I'm going to keep a copy in my rental office. The fact that it says it has to be kept in the rental office makes me think that there might be a mom and pop carve out there, because mom and pops usually don't have rental offices. Which is not to say that larger property owners do. I know people that own 5 or 6 houses and don't have a formal office. But that's something we definitely need to look at. Does the landlord have to get them to sign a new Bill of Rights every year? No. The only time that I would think that might be an issue is if there's some change to the legislation that updates the rights, then I think they would have to get a new one within 12 months. But once it's been presented and signed and a copy has been given to the tenant, and they have a copy to show to the court if they need to, they're good to go. I'm going to try and move it along here, because I do want to give James his full hour. Let's see. Come on, change. Oh, there we go. They have to offer new, blah, blah, blah. Wait a minute. We somehow jumped back here. Keep going. There we go. Tenants of public housing authority properties were entitled to be provided with contact information for the legal aid office only when they were served with the unlawful detainer. Now it is extended to all tenants receiving government subsidized rent assistance. So when the landlord-tenant relationship begins, they have to be given that contact information. They also have to give it to them if an unlawful detainer is filed again. So the former law is still in effect, but they just have a new requirement. Does the requirement that the tenant's Bill of Rights be presented include leases prior to the date that the requirement became law? Yes, if the lease renews. If it renews or converts to a month-to-month, which is considered a renewal, it must be presented at that time. Unless the lease is of an extremely long term, in other words, more than 12 months, that would be a moot point come July 1st of this year, because all leases will presumably have 12-month leases will have ended by that time. And if the lease was entered into after July 1st of last year, it should have been done at that time. Virginia Department of Housing and Community Development. Thank you. That was the department name neither one of us could think of. The links to the tenants' rights form that is in the outline is incorrect. Oh, I'm sorry. It may have changed since that outline was put into effect. Let me put that up. Thank you very much for that. This is the correct link to the tenants' rights form. Governments do tend to change their URLs a lot, which I don't like. Again, I need to move on here quickly. I'm actually supposed to be at my break now, so and I've got quite a bit more to do. So we're going to run through these pretty quickly. A particularly egregious circumstance was when housing projects were slated for demolition. There was virtually no notice of this. If a housing project was going to be completely vacated for remodeling, as happened in Lincoln Park here in Roanoke about 20 years ago, They literally cleared everybody out and remodeled it and then opened it back up, or if they were going to tear it down like they did with Cabrini Green in Chicago. There was really no requirement of notice. Now they have to give 12 months notice, and they cannot increase rent during that time. That should say, I don't know what it changes to convictions, conditions. People are supposed to be checking my spelling and grammar here. Conditions, nor evictions for the purpose of clearing the property in advance. Okay, so they can still do evictions that are, for non-payment of rent or violation of provisions of the housing agreement, but they can't simply start evicting people until after that 12-month period, to clear it until after that 12 months. So we do want everybody to continue staying healthy. Hopefully by the time of our October seminar, we will not be worrying about staying at home as much as we will be worrying about the dangers of going back out into public again. Security deposit insurance. This was a new one on me. I'd never heard of this before. Of course, it's been a long time since I was a renter, and you had to make a security deposit. As of 2/20, landlords are now required to permit a tenant to use security deposit insurance in lieu of making required security deposit or any portion thereof. This allows tenants with limited savings to be able to not only get their first rental, but if they need to move, not to have to wait that 45-day period to get their security deposit back. Another advantage of this, of course, is that the insurance company that's covering the move-out expenses is in a much better position to negotiate with the landlord on whether or not there are monies to be collected for cleaning and repairs of the apartment.
I'm late for a very important date. No time to say hello, goodbye. I'm late.
So late fee reform, you might remember I mentioned early on when late fees were, they are an implied term in all leases now, if not actually written out. Despite Virginia's longstanding support for freedom of contract, many courts would refuse to uphold late fee provisions that they considered excessive, while others would award any late fee that the lease called for. So effective April 22nd, this was an emergency legislation signed by the governor. A landlord may charge a late fee of 10% of the periodic monthly or weekly rent, or 10% of the remaining balance due, whichever is smaller. Okay. And only if the late fee is provided for in the written lease agreement, which of course it is an implied term. This is not one that will be implied in the absence of a lease. So while the 10% late fee is an implied term, if it's not actually in a written lease, this new legislation sort of took that away. There's also a new change to the way tenants can get repairs done that render where the apartment is not up to code, does not meet livable standards. So it's not just minor repairs, but things that that are necessary through the tenant's assertion. Starting July 1st, they have a right to get the repairs done themselves if the landlord will not do them within 14 days. And they can do that up to $1,500 or 1 month's rent, whichever is higher. James, I'm actually into your time, so I'm going to try and move it along a little more quickly here. We got a very real problem in Virginia with our federal workforce and our federal contractors force. When the government shuts down, There previously was no way to keep them from being evicted. They now have grace periods of 60 days, one time for renters, and a 30-day renewable up to 4 months after the government returns to work for mortgagees who fall behind. So even though federal employees are awarded back pay, of course, federal contractors are not. So even with these new graces, it's sometimes difficult. I did mention at the beginning of the outline, I would not be talking about COVID pandemic relief measures. I consider this to be a survey course, not a pandemic course. So we'll go on and talk about self-help evictions, which I believe is our last topic. These did get worse during COVID, as landlords chafed under not being able to use legal processes. Well, yeah, I did say I wasn't going to talk about COVID, but we're just going to say that these are issues that are going to be litigated in the coming years as to whether or not the limitations on evictions during the coronavirus were unlawful takings. Let's leave that alone. Glad I can move through this quickly instead of getting into a political discussion. Self-help evictions. So one of the reasons that they were very often successful is once a landlord had locked you out or actually put you on the street or cut off your utilities, before you could get relief from the court, you had to get service on him. And believe it or not, sometimes they would try not to get they would try to avoid service of process. So now there is a process for an ex parte hearing to regain possession if you have been unlawfully excluded either physically or, and I'm drawing a blank on what the word is, but when they've shut off the utilities, somebody knows what the word I'm looking for is. Maybe I just know too many low-income homeowners, but will Virginia government help pay the mortgage while the owner isn't receiving income from the federal employees? Constructively, thank you. Yes, constructively evicted. The answer to that question is no, they won't help them pay the mortgage, but they can get 30 months extension, 30-day extensions every 30 days up to 4 months after the government returns. So they won't actually help pay the mortgage, no, but they will keep the foreclosure from happening. We also had two, let me get back to that one just so I can say it very quickly here. Tenants will require the right to seek expungement of dismissed unlawful detainer actions. Even a dismissed action was kept on the records for 10 years, and landlords do check for that sort of thing. And in fact, those of you who know general district courts are not particularly good about expunging their own records. So even 10 years, they probably say it longer. Two very quick changes that involve mobile home parks, where typically you lease the land but own the home. The new law expands the required notice that the property will be sold and put to a different use. That is to say that the mobile home will have to be moved. They now have to be given a 12-month notice and also an opportunity, interestingly enough, to purchase the property collectively and turn it into sort of a condominium mobile home park. There are very specific guidelines for how that goes about. I'm not going to get into them. But the other big change is if the property is sold and repurposed, residents must receive relocation credits of at least $2,500, and in Northern Virginia, it's actually $3,500. So we're going to take our break now. I apologize for running about 9 minutes over, James, but I will be turning control over to James once we come back. Please enjoy this brief interlude.
Hurry, hurry.
Okay.
We're on now.
Let's go.
Our turn. Our turn. Come on, guys.
Am I late?
This is our big chance.
I'm so nervous.
Everybody ready?
Don't ruin this one.
Cows. We're remarkable cows.
You're not
And wherever we go, it's a fabulous show. Oh, you know we are cows. That's right, we're cows.
Hey, you're not
Such
cows.
remarkable.
He's got a point.
Well, you're right. Technically, we're not cows.
We're aardvarks.
Yeah.
Yes, indeed. Yeah.
That's true.
All right.
And wherever we go, it's a fabulous show. Oh, you know we are aardvarks. If you thought that all we could do was go slurp, slurp,
Am I missing something?
quack.
here?
All right.
What's
So
wrong
what
with
sound
moo?
does an aardvark make?
Beats me.
Beats me
I
too.
don't know either.
We do quite a lovely intermission song.
Well, that's true.
Yes,
Well,
and
yes.
here it is. Oh, we've come to intermission, so it's time to stretch your toes. And if you want to know aardvark, you should also stretch your nose. When you hear the bell go bing bong, intermission has begun. And when you hear another bing bong, then intermission's done. Oh, we've come to intermission, so it's time to stretch your toes, each and every little toe. And if you're still an aardvark, you should also stretch your nose, your nifty nose. We hope you like our singing. We hope you like the show. We hope you like spaghetti. We sound great. Spaghetti. Uh-oh. It's time for us to go. Now intermission's over. It wasn't very long. Please hurry to your places to enjoy another song. Thank you.
I think I noticed not for the first time that presenter is misspelled in that last public service announcement. So welcome back, everybody. I'm going to stop sharing my presentation. I am then going to turn control of this meeting over to Mr. James Steele, who is, let me see, how do I do that? Make him host. As soon as I click this button, he will be in charge. But before I do that, one last question from the first hour. Somebody said, but what about late fees? I assume that was in reference to the relief for government workers and contractors during government shutdown. No, the legislation just stops evictions and foreclosures. It does not forgive any type of payment. And if that was not made clear in the presentation of the outline, I apologize. It is not a waiver of rent or a waiver of mortgage. It's a waiver of legal process during that time. For renters, it ends when the shutdown ends. For mortgagees, for mortgage payers, it is 4 months after the shutdown ends. Why they made the distinction between mortgage payers and renters who, you know, it seems to me are in very similar situations, I'm not sure. But I am going to click make host, and James, take it away.
All right. Hopefully everybody can hear me, and hopefully I can properly share my screen here. Let's see. Okay. Does everybody see residential landlord and tenant law in 5 documents on the screen?
I do.
Okay. I assume you stand for everyone in this case.
If I do, hopefully everybody else does.
Okay. My name is James Steele. Today's look is from the I'm on a 2-week road trip with my children collection, and I didn't bring a razor. So thankfully we have a presentation we can look at instead of my face. Like I said, my name is James Steele. I cleverly named my office the Law Office of James Steele. There are about 5 of us, attorneys, me, my father, Alan Steele, my youngest brother, Justin Steele, Rodney Jefferson is in our satellite office in Henrico. And finally, we've just recently welcomed John Koehler as of counsel. So let me get started here. Okay. John, if questions come in, can you please direct them to me, because I'm not going to be able to watch the chat screen.
Yeah, I've got the chat up, and in fact, I just posted, I intended only to post the link to the CLE, but somehow I posted the stuff about the poll, which isn't going on, so ignore that.
Okay. So I've been doing this now for about 10 years here in Roanoke, where I'm in Arizona right now, but my office is in Roanoke. I do about 37% of my practice year to date is landlord tenant, and about 19% of my office's practice is landlord tenant. So the way that I would like to approach this is, I think, well, it helps me to organize my thoughts by looking at 5 major documents that are going to pervade any landlord tenant practice. Some of this stuff John has already covered, and so I will skip through that. I will say, I'll reiterate, this is definitely a 101 level course, and this is going to be from the perspective of an attorney advising his or her clients. So first of all, we will look at, well, actually, let me check my notes, make sure I'm not leaving anything out here. Oh yeah, one thing that's worth mentioning, there are a couple of documents that we're not going to look at, such as a warrant in debt or summons for unlawful exclusion, but they're relatively self-explanatory. And I'll say also, most of my landlord-tenant practice is in the 23rd Judicial District, and your mileage may certainly vary from court to court. So starting with the lease, this is likely the most common contract maybe in America that people enter into. It does follow contract law, but of course it's that law is tempered by the Landlord Tenant Act and common law. I would say the first takeaway on leases is longer is not better. You will encounter what I would consider corporate weaponized leases that are like 40 pages long and just utterly unnecessary. What's showing on the screen now is the lease that I use and recommend to people. It's 2 pages long. This is Ross Hart's simple lease, which he at least used to have on his website. And if it's no longer there, I can make my version available. It's got some slight updates, and actually the one pictured on the screen needs a little bit more. As far as a middle ground, I know somebody asked about this. The Virginia Association of Realtors has a lease available online. It says it's copyrighted. I don't really understand exactly what that means. And it says that you're supposed to be a member of the Virginia Association of Realtors to use it. I don't use it, so I don't know if you'll run into any problems, but it's widely available online. It's their Form 200. I would say it's inelegant, but sufficient. They squeeze into 14 pages what Ross Hart was able to do in just 2 pages. as John indicated, let me just glance at my chat. Okay. As John indicated, the Landlord-Tenant Act has lots of gap filler provisions. In fact, you can write a lease that is extremely rudimentary, and if you do this practice much at all, you'll find some very rudimentary, very poorly written leases. So because of these gap fillers, there's actually very little that absolutely has to be in a lease. And so I want to go over a couple of what I would consider the gaps and provisions that are just well worth keeping in mind. The first one, the renewal and termination provisions. This is covered in the Landlord-Tenant Act gap filler section, but it's just very good to keep in mind how you will terminate a lease. For example, in this one, the initial term is 1 year. After 1 year, it converts to month, but in order to terminate it, you need to give at least 60 days notice.
James, can you hear me?
Yes.
We have several requests to have you speak up.
Okay.
Having difficulty hearing you compared to John and his music.
Right.
So I apologize again for the loud music. I don't guess you have a lavalier mic that you can use. So just maybe lean a little closer to your computer microphone.
All right, sorry about that. Hopefully this is better. So in this example, notice has to be given at least 60 days in advance, and at least local practice in the 23rd. And the way I write my leases is leases always end at the end of the month. So for example, if I were using this lease and I gave notice today, it would actually end on, I guess, June 30th. So anyway, you want to keep a close eye on this provision. Lots of leases, especially these corporate leases, will renew for the entire term, whether it's a year or 2 years. And I can't think of a lot of great reasons to do that. It seems mostly like a trap for tenants, but maybe there's a reason. I'm not sure. I don't like using it myself. Okay, the next, attorney's fees. This is the one that landlords, well, and tenants are very interested in. Usually I can spot a very poor lease because it doesn't have a section for attorney's fees. Landlords will not be able to win attorney's fees without a provision like this. But with a provision like this, if they win, they're very likely to recover attorney's fees. I will note, and I always advise my clients, it's pretty rare that you're going to be able to recover all of your attorney's fees. Judges will award it, and it's usually a fraction of what landlords normally pay. And of course, winning attorney's fees against a client or against a tenant who can't pay is not worth much money. Okay. And lastly, late fees. John touched on this. You can't get late fees if they're not in the document. I will add one thing to what John said. I have had much more success with early discounts instead of late charges. So for example, if somebody pays after the 5th of the month, in this lease, they pay $25. But if they pay more than 5 days before rent is due on the 1st of the month, then I knock off $25. In my experience, it's not good to generalize, but in my experience, landlords tend to be penny wise and pound foolish. And so many will not want to do a credit like this, but frankly, it's going to save most people money in what you save in lost rent and attorney's fees and your time and all that. Somebody who can't pay their rent at all will not, an early payment credit or a late charge won't do a thing to get that rent paid. But somebody who's right on the line where they're deciding which bills to pay, the early payment credit, in my opinion, goes a lot farther than a late fee. Okay, that is all I'm going to say about leases right now. Again, I'm just not going to pay attention to this chat box. So John, please interrupt me if something comes up. So moving on to the next document.
We had a couple of inquiries, but I was able to respond to them myself. So.
Okay. All right. Sounds good. So, and I'll go back just a little bit. The way this course was billed, it was pre-lease to post-removal, frankly, I don't know much to say about pre-leasing. So that's why we start with the lease. If you have specific questions, I will do my best to answer them. And the other thing I'll mention is there's a robust list of tenants and landlords' rights and responsibilities in the document that John made available with the CLE. I'm not going by it line to line, but it has everything that I'm going to present, and probably a lot more. So next up, let's talk about notices. Oh, sorry. Let me go back just a little bit to the lease. We talked a little bit, there were questions about this new statement of tenants' rights and responsibilities. And John is absolutely right that the law says you can't bring an action unless you've given this to them and it's signed and all that. I found in my actual practice that there's no teeth, or at least locally, they're not really enforcing much as far as that statement goes. And if your landlord if you're representing a landlord and they didn't give that statement at the beginning of the lease, or they didn't give it with a notice, or they didn't give it before filing, you can usually just cure it by sending the tenants a copy of it now. I don't know if that's how it's supposed to happen, but
that James, that is absolutely not how it's supposed to happen. And I'm very disappointed to hear that is how the courts are treating it. It may be something you and I need to discuss at another point.
Yeah,
and perhaps discuss with the chief judge of the circuit, who should be made aware of that.
Yeah, and
I was going to say he should not be tolerating that. And even the idea that you can somehow cure it after the suit has been filed, when the suit is in fact a nullity. Unfortunately, I'll just mention here, and I'm sorry for breaking in on you, in case anybody out there doesn't know, almost all of this litigation takes place in the General District Court.
Yeah.
And as a result of that, it's a court not of record. So much of it is never going to be reviewed by a superior court. Cases that do wind up going into the circuit court, I think, are usually more complex because there's other issues involved. So the only way to make sure that the law is being followed, and I mentioned in my presentation that general district courts before some of these laws were changed were just all over the place, and I gather maybe they still are. But is that you do have to, sometimes you have to act proactively to make sure that both from the tenant and the landlord's perspective, that they're getting the rights they're entitled to. Something that I know many lawyers are reticent to do because they have to practice in front of those judges. But I'm rapidly gaining a reputation as a gadfly, so I'm not worried about that. Sorry to break in, James.
No problem. You'll find if you do this very long, there are several provisions in the Landlord-Tenant Act that look really good on paper, protections for tenants or protections for landlords, but in actual practice, they just don't get enforced that much, and there's not much teeth to it. So you'll just get used to your area. One other thing, I didn't highlight this on the lease. There's a practice on deposits. A lot of people will charge a non-refundable pet deposit in their leases. The Landlord-Tenant Act has no support for a non-refundable security deposit. I think that's kind of a ridiculous item, but you'll see it a lot. If you're defending tenants, I would fight against those every time. And yeah, that's all I'll go into now. I hate leases that try to make money off of the security deposit or cancellation or termination fees, etc. Okay. On notices, you can't, as John mentioned, the law has now clarified, you can't initiate pretty much any Landlord-Tenant Act without proper notice. In front of us now, we've got a 30-day notice. It hasn't probably been as updated as it should be, but I want to touch on one, the different types of notices that you're going to deal with, and two, the boilerplate that I always include. So let's see. As far as notice types, a 30-day notice like the one shown, there doesn't have to be any reason except for it's a month-to-month tenancy or the lease is coming to an end. You just need to give them 30 days notice. that the lease is coming to an end. And like I said, at least in the 23rd, the lease needs to end at the end of the month. You'll come across 21/30-day notices. That's if somebody's breached in the lease in some way that they can remedy. They have 21 days to remedy the problem, or they need to leave within 30 days. If they have that problem again, even if it is something that they could remedy, you give them a 30-day notice that they've violated it again, and there's no remedy, and they have to leave within 30 days. 5-day pay or quit notices used to be the most common notice. If somebody didn't pay, you give them one of these, and then 5 days later, if it's still not paid, you file. During COVID, there's no 5-day notice. It's been converted to a 14-day notice. I'm not going to go into details, but if you ask me about it, or if you do this, you'll get familiar with it really fast. And unlike the 5-day notice, the 14-day notice also has if they fail to pay within 14 days, or they enter a payment plan and then they break the payment plan, you can't then head straight to court. You then have to give them another 14-day notice that they've breached the payment plan or failed to pay. And then after that, full 28 or 29 days, then you can file. And just a general note, if you're trying to evict somebody for non-payment right now, you're going to have a bad time. The pandemic, especially the CDC's moratorium, has made evictions very difficult right now. Okay, here's some boilerplate that should be in every one of your leases. The notice of rent with reservation, or acceptance of rent with reservation. I think of this practically as just magic language. Your client doesn't need to know what it means. They just need to include it in their notices. I would include it in a lease. I would include it with my receipts as well. Rent with reservation essentially just says to a tenant who's trying to pay, I will accept your money because you owe it, but that doesn't mean that everything's all right between us. I may still pursue legal action. And so I believe it's both statutory and common law, but just include it. And lastly, some boilerplate that's not on most notices, but really ought to be, is the personal property notice that just advises the tenant that anything they leave in the property after vacating will be disposed of within the 24-hour period after termination. There are, under the Landlord Tenant Act 55-1-1254, there are a lot of different ways to handle this notice and a lot of different timeframes. This is the easiest and the fastest way to do it. And so that's why I recommend including it, because this comes up a fair amount. Landlords are going to ask you, well, what do I do with all this stuff that they left behind? Okay, and then this is not exactly a boilerplate notice, but it's still really important. As far as the way notice is delivered, landlords get this wrong all of the time. First of all, it needs to be given in writing. Don't just call them or tell them in person. Please don't text it or even email it. I recommend printing it out on paper and then taping that paper to the tenant's front door, and then also mailing it first class to the tenant that day. Don't use certified mail. People do it all the time, but it's a waste of money, and they can actually just refuse to sign for it, and then that's not very helpful. I've seen times where I suspected people signed the wrong name and then claim they didn't get it. Just send it through the post office, regular first class stamp, and save a copy for your records. If you want to take a picture of it, post it on their front door, that's going to be enough. You don't need to get the sheriff involved to serve it or a private process server, but serve a copy physically and mail a copy. And
James,
yeah,
just want to give you a question. I'm pretty sure I know the answer to. Is that true? They're talking about the 14-day notices. Is it true of mom and pop landlords as well? I believe the correct answer is they are no longer mom and pop landlords. They're just landlords. Well, and so unless you know of a carve out, I think it applies to all landlord tenant relationships.
There is a bit of a carve out, but it doesn't affect it in this situation. The new COVID law differentiates between people who own up to 4 properties and people who own 5 or more properties. Both of them are going to be subject to these new 14 days, the double 14-day. The difference is larger landlords, their 14-day notice. It's mandatory that they offer a payment plan for the tenant to get on. And the details of that payment plan are in the statute, but mom and pops are not required to offer a payment plan. Both of them are required to give information about Virginia. What is it? Virginia something 11. The social services hotline to get people connected with help, and they're required to inform them about the RMRP, the rent.
So
and
somebody says Virginia 211.
211. Thank you.
And
Yeah.
and I'll mention, it's interesting that you said, because if it specifically says 4 or less or 5 or more, then that's actually one off from the original mom and pop.
Yeah, I know it's kind of strange. And by the way, they're considering units, not properties. And so, one quad would be
considered four units.
Right, exactly. The other thing that the new 14-day notices require is it requires a tenant who can't pay to apply to the RMRP, the Rent and Mortgage Relief Program. And if the tenant doesn't apply, it requires the landlord to apply on behalf of the tenant. So there are a lot of new affirmative requirements. We're not going to go into great depth about them, but just know that they're there, and ask me a question if you need to. But I trust you all can word search the statute pretty well. Let's see. Yeah, and actually that regarding the different types of notices, just a principle that I live by. I make no effort to memorize things that I can quickly look up, and I make no effort to spend a long time researching things that I could quickly just pick up a phone and call somebody who I know has the answer, or send them an email. I know that when I'm asked questions, I'm happy to answer them, and I've benefited tons in my practice by just calling people that know more than me. So let's see. I think that's all I need to say on notice right now. Yeah, so we're going to move on to the summons for unlawful detainer. This is the central document in any eviction. I would say 99% of evictions are going to involve this form. The only real exception is there's certain circuit court issues where you're just going to write it out. But since the General District Court does have original jurisdiction, you're going to use this form a whole lot. In my practice, I have found landlords usually do not come to me.
p.m. Eastern time.
Landlords do not come to me as early as they should. It would be really ideal if they came to me when they were deciding what lease to use. A lot of landlords will, when they're starting out,
Presentation. What will happen is you will be sent.
I'm going to mute John there. Landlords really ought to spend an hour sitting down with a knowledgeable attorney, go over all their questions, get copies of the documents and forms they're going to need. And then they've established a relationship with the attorney in advance. And that's actually going to save most of the money down the line. But that being said, they're never going to, most of them don't do it. They'll come to you not only after they filed, but after they've been to the return date and maybe even the first trial date. And then they'll contact you and tell you they need help. But if you can get to them early, it's well worth it to convince them to hire you to fill out this form. I have absolute faith in everybody in this CLE that you can fill out this form perfectly. And I have zero faith in most of my landlord clients that they're going to get it right. And most of the problems that I encounter in court are from landlords that have messed up this stage of it. So let's see here. So yeah, the ounce of prevention, draft this thing yourself. I charge a flat rate. I charge 12 minutes for General District Court forms like this, and 6 minutes for cover letter. And I think it's worth it. This is kind of a dumb thing, but take a look, download the most recent unlawful detainer form. They don't change that often, but when they change, it can be significant. This one was in late 2019, and it actually reversed some checkboxes. So things that you used to check, you wouldn't check, or vice versa. It's well worth just grabbing the newest form from the court's website. So this is just a really practical matter. When you fill this out, you're going to want to call the clerk and say, hey, if I drop this by in person today, or if I put this in the mail today, what return date and time can I use? And then you're going to just add to yourself. There's not a fillable form part, but you're going to write it on or use a PDF editor and include it. That'll save you a lot of time. You will also include that information up on the right. And briefly, if you see kind of down in the middle right half of the screen, in the 23rd district, we use return dates. So the first date, everybody just shows up and says if they agree or disagree, and set dates for pleadings and for trial. In some places, Franklin County General District Court, they just try to have a trial on the very first day. And so know your jurisdiction, and yeah. When I go to a return date, I almost always ask for pleadings, just because I like to limit what the arguments are going to be at trial, but it can add a little bit of expense for your client. Okay, a major source of problems I see on these, is double check whose name you should be filing under. I see people who own property as an LLC filing in their own name, or vice versa. I see people filing with LLCs that are defunct because they haven't paid their fees. So I strongly recommend get in the habit of checking the State Corporation Commission website and check your local GIS system to figure out who the actual owner of the property is. Also check the lease to see who's managing it. So you're suing in the right name. I don't know that there's much, most judges won't let you cure if you're just sued in the wrong plaintiff's name. And then this is obvious. On defendants, name all the adult lessees and also name the guarantors if there's any money involved. I would name the guarantors regardless, frankly. Okay. One problem I see, especially with landlords representing themselves, but also sometimes attorneys that don't do this a lot, is they will just submit the summons for unlawful detainer by itself. We send a stack of paper when we do these. We send a cover letter, obviously, describing to the court what we've got. We've got the original unlawful detainer form fully executed and notarized. We've got as many copies as that court requires, and it's worth asking, but the answer honestly doesn't matter. Every clerk will tell you a different number of copies, so just include sufficient copies. And let's see, service members affidavit is required. It's a very easy form. You Google it, and then you go to the Department of Defense Manpower Center if you've got their social security number, and just make sure that your defendant is not out on active duty, and that's why they're not paying their rent. Include a copy of the notice. That's key. The judges want to see that pretty much first thing. Include a copy of the lease. Go ahead and highlight the attorney's fees section if there is one, because the judge will be looking for it. If the amount of rent or late fees is at issue, highlight those as well. Include a statement of account if money's involved, just so people, so the judge can quickly figure out how much they owe and why they owe it. I will say, so I mentioned before, due to the
James,
yes.
First of all, I apologize if my mic was on when I took that phone call.
No problem.
Secondly, there's a question that says, what if the owner is one LLC, but the landlord uses a separate LLC to manage and lease? Would you file in the name of the managing leasing LLC?
Yeah, that's a tricky question, because there's a regulation, a little known regulation that says that a property manager, this is off the top of my head, so it may not be perfect, but a property manager has to be a real estate broker if they're not the owner or a family member. And so technically speaking, in a situation like that, I would file as the owning LLC instead of the managing LLC. But practically speaking, if the managing LLC's name is on the lease, no judge is going to care. But I would argue that an LLC like that is not a real estate broker and is not the owner of the property, and so technically they shouldn't. But there's no teeth to that rule really either. So either one is probably fine in that case. I know that for anonymity, I guess, is the primary reason for something like that. Some landlords definitely like to do it. I feel like it's not usually worth the trouble, but
yeah. And then another question: what if you don't have their social security number?
There's a helpful section on the service members affidavit that just says, I don't know. I can't tell if they are a member of the armed forces or not. I know some attorneys just always jump to that, but technically I think you should do a good faith search if you can, if you have the information. Okay, just touching real briefly on coronavirus and its effect. The CDC moratorium has been extended as of a few days ago till June 30th. So under federal law, you cannot evict somebody for non-payment until July 1st right now. So I've been advising my landlords not to enter into long leases, just enter into month to month right now. So you can terminate, just at the end of a month instead of, however long the CDC extends this moratorium. So even if I'm suing, for example, because they've breached the lease, they're doing something illegal at the property, even if they owe back rent, out of an abundance of caution, I have not been including it, and I've not been including attorney's fees on this form. I may be going too far. I've just been trying to steer clear of this prohibition on evictions for non-payment, but that does lead to one interesting problem, which is at the end, if you win, you should talk to the judge about how much rent is owed, so they can include it in the appeal bond. Because if you don't, the appeal bond is going to be nothing. They're going to pay like $130 writ tax or whatever that's called to appeal it, and then you're going to be you're going to be months behind schedule essentially. So I don't include the back rent on this form. But I do bring it up if I think an appeal is a problem at all. You can.
Okay, we have another question. It says, do tenants have to affirmatively indicate they are having trouble paying rent paying due to COVID under the CDC guidelines? So do they have to make an affirmative claim, or is it just everybody is entitled to the moratorium?
They have to make an affirmative claim. The CDC has given a good form. It's actually a declaration under penalty of perjury. I have found also, though, in this case, the courts are not being very strict about it. If they've essentially said for any reason that because of the pandemic they can't pay, then the court is putting them under the protection of this CDC moratorium. But yes, technically, the lengthy CDC announcement goes over all of the things that they have to include in that. But as a practical matter, any half a claim of pandemic-related problems, and you're going to be stuck with this. Virginia also provides for some protections right now, but at least until July, they are less than what the feds have done. I've already talked about these. 14-day notice replaces 5-day notice, mandatory payment plan for 5 or more units, mandatory rent relief advisement, mandatory RMRP application, and no late fees if somebody can't pay because of COVID right now. At least last time I checked the statute, that's, I believe, what it said. Okay. I think that's all I've got on the summons. Let me double check my notes. Okay, yeah. All right, so moving on to the writ. This is an area that landlords also ask me a lot of questions about. Landlords who have been doing it long at all realize that it's very easy to get a judgment. In fact, most of the time it's default judgments, but that judgment is not worth anything. The money part of it's not worth anything if you can't collect, and the possession part of it is not worth anything without this writ, the writ of eviction. So when you win in a summons for unlawful detainer, the judge will either give you immediate possession or 10-day possession, depending on the circumstances. With immediate possession, you can go across the hallway to the clerk's office and you can file this writ of eviction immediately. With 10-day possession, you have to wait 10 days. Regardless, the sheriff's not doing anything with it until 10 days have passed from when you won at trial. And so as a practical matter, that there's not much distinction anymore between immediate and 10-day possession. And if they appeal it and they perfect that appeal, it's going to immediately cancel that writ of eviction. Just a note on landlord-tenant cases or eviction cases, unlike most civil cases, appeals have to be perfected within 10 days instead of the standard 30 days. And so if there's an appeal bond, they'll need to pay it within those 10 days.
James?
Yes.
Breaking in again, somebody comments, says a landlord is defined in 55.1-1200 as the managing agent if the name of the owner is not disclosed on the lease. I'm wondering, do you think that cures the problem of the managing agent not being a realtor or a family member?
Yeah, probably. Honestly, it's a problem that doesn't really need curing, because unless a defense counsel raises the issue, I've never seen a judge raise that regulation sua sponte. So it may well cure it, and maybe my information here is a little bit stale. And I guess it's possible that you could be doing something right under the Landlord-Tenant Act and doing something wrong under this obscure regulation, and there's really no penalty for that except for like DPOR sanction. So let's say yes. I think it'd be fine if the managing LLC or managing individual is on the lease. Then I think it should be fine to sue in their name. If they are not on the lease, I would sue in the owner's name or the owner LLC's name.
Yeah, somebody says there may be unauthorized practice of law issues. People that work in the general district court a lot know that this is one of those things that general district court judges vary on how much they're willing to let people get away with acting as their own attorneys or acting for attorneys on behalf of corporations or other type of entities. It depends very much on the judge.
Mm-hmm.
I think this falls under the category of you really need to know your court, to know whether you're going to raise an issue like this. And while we were talking, we had a question: can a landlord discount from the security deposit all the rent that was not paid by the tenant? Can the landlord ask the tenant to replenish the security deposit if the landlord takes money to cover the missing rent? What things cannot be recovered from the security deposit? I have some idea of that, but I'm going to let you answer it.
So it's yes to both of those questions. They can recover the unpaid rent from the security deposit. They can ask the tenant to replenish the security deposit. But if the tenant fails to replenish the security deposit, I don't think you can get through the CDC moratorium for now.
Just as a separate aside there, that may also be one of the disadvantages to landlords of this new law requiring them to accept security deposit insurance. Is security deposit insurance does not pay for things like missed rent. It only applies to repairs and cleaning and other things that we traditionally associate with the security deposit being retained after a normal termination of the lease. So if a tenant says, I want to use security deposit insurance instead of paying you the 2 months rent, the landlord has to accept that, and then they don't have that security backing up for unpaid rent. So something that landlords may possibly be approaching the General Assembly about, saying, yeah, you know, you can't keep that from us. But anyway, we'll see. I will mention that we're now at our roundup point, so everybody gets the 2 hours. If you've been here the whole time, James, you are more than free to continue on, because I know that there are people who want to hear what you have to say, but I'll be posting the link to the CLE form again, and trying to get, I see we have about 135 people online right now, which is about normal for our level of registration, about 85%. So I'll just say very quickly, look for that email confirming your attendance with the link or the attachment of the CLE form. If you don't hear from us by, say, 9 o'clock tomorrow morning, then please do contact us to make sure that we have a way of verifying your attendance. And James said that he will get a printout version of his forms that we will forward to everybody at some point. That will probably be not today, but certainly sometime this month after he gets back from his family vacation. We don't want to intrude too much more on the time. So I'm going to turn it back over to James. I'm going to post that link, and I hope everybody who is going to be leaving at 4 or staying with us, either one, has a wonderful rest of the week. James, back over to you.
Okay. John already mentioned this. Don't forget about the right of redemption. It's now been extended up till 48 hours before the eviction. So, yeah. Okay, as a practical matter, you don't necessarily have to put the plaintiff's information here. You can put the property manager or whoever it is that's going to meet the sheriff at the property for the eviction. They want somebody's cell phone number that they can call and schedule the date, and then they're going to meet them there at the property. And for those who haven't done this, all the sheriff does is stands there and makes it official and makes sure that nobody does anything crazy. The landlord or their manager is going to need to have people there that can change locks. They're going to need to have people there that can remove personal property, etc. The sheriff just wants to get there and oversee it. So it definitely include their cell phone number there. And then random facts, John brought this up. They expire after 6 months now. You cannot, if you win in court and then you renegotiate or modify the lease or accept money without saying it's accepted with reservation, then you can't continue with the writ. And there's a little, I think there's a little section where you have to certify that when you sign this. And then lastly, this is the only general district court form that I know off the top of my head that can also be used in circuit court, but they will give you some funny looks. But this is the form that the sheriff's most used to, and so I tend to use it in circuit court in cases where there's been an appeal or some other issue that's led to an eviction. Okay. And lastly, we've been kind of focused on, well, very focused on landlords, but let's talk just briefly about tenants assertion. This is the big tool. Yeah.
Up to what point in the litigation process may a tenant submit the CDC declaration?
I have found that they've been able to submit it up to 60 days after you win, because these motions to reopen are being granted liberally in at least Roanoke City. And so unfortunately, yeah, they've been using them up to the very end. This is a really frustrating time for landlords.
As I said in my half, I think we're going to be seeing some unlawful taking litigation coming out of all of this at some point. That the government's going to have to come up with an argument that these landlords who have many of them suffered quite significant financial impacts from this, aren't entitled to some type of compensation.
Yeah, I mean, I believe it's an unlawful taking. I mean, I'm certainly behind the spirit of the law, but you know, the Supreme Court has said that a temporary taking is a taking nonetheless, and so I think there's a constitutional issue, but you know, it's going to be over before it's litigated too much, I'd say. Okay, so the tenant's assertion, this is essentially the Swiss Army knife in the tenant's toolbox here. Whenever the landlord has broken the law or broken the lease, as long as you've given them some notice that they need to fix a problem, if it can be fixed, then the tenant should file a tenant's assertion. And you know, a lot of times tenants on the defensive can feel quite powerless and feel like the Landlord-Tenant Act is on the landlord's side, but the tenant's assertion is more powerful than a lot of people realize. And one of the real source of that power is the ability to file first in court is quite helpful. One, because it triggers the anti-retaliatory subsection of the Landlord-Tenant Act, so they can't turn around and file against you if you filed first. You know, at least if you can show that the only reason they're suing you is because they're mad that you filed one of these assertions. And two, if you lose, you know, you just lost the case. You don't have this judgment on your record. So I find that it's very, very helpful for tenants to make the first move here. The way it works, you make sure that the landlord has notice first. The statute doesn't say exactly what constitutes notice, but you know, if it's a non-emergency, maybe 30 days. If it's an emergency, you know, maybe 36 hours. It just depends on the emergency. But I found these are effective because landlords don't want to put up with the hassle of hiring counsel or defending themselves. Landlords that operate as an LLC or corporation may be forced to hire counsel. I feel like both those statutes and the interpretation of them has been muddled in the court. And so but the other thing about John mentioned, the law has been updated with these fee shifting provisions. Tenants are more capable of winning attorney's fees now than they ever have been, but you've got to counsel them that it's still unfortunately rare. And even when they win attorney's fees, just like landlords face, they may not get everything they spent. And so, you know, unfortunately, a tenant still needs to have some money to get a lawyer to handle one of these. Oh yeah, but I was going to say, if you have given them proper notice, you fill out this form, file it in the court, and you start paying your rent into escrow in the clerk's office, and that automatically sets a trial date or a return date for the landlord to come into court and explain why they haven't broken the law or the lease, or why they shouldn't, you know, win whatever the tenant's asking for. Tenants usually can't win much more than they've paid in to the escrow. I don't think it's impossible, but as a practical matter, that's just the way that it's been, at least in the 23rd. And I mean, except for maybe attorney's fees, but they're very effective in order to get out of a bad lease or fix a bad relationship. They're not effective at all if your client is trying to win big somehow. There's not much money to be won, but you can get out of a lease and you can fix a lot of problems. Okay, I'm kind of flying through everything, but I think that is essentially my presentation. So I'm happy to answer any questions.
Okay, James, if you will click on my picture, and there'll be 3 dots, and then you click on the 3 dots, and it'll allow you to turn control back over to me. And looks like we still have over 100 people online. This is the point at which you can ask any questions. Feel free to unmute if you want to chat with us. We'll stay online for a little while longer, but we are officially done. We finished just about exactly right on time, despite my running over. And so a lesson to learn for you there, James, is make sure you go first from now on.
Smart.
And hey, it looks like you have turned control back over to me, or no, well, maybe not.
I thought I did.
Great presentation, man. Thanks a lot.
Okay.
Great presentation.
Thanks, Dan.
I have a quick question.
Go ahead.
Do you have to put the security deposit in an escrow account?
I don't think so.
No, last I remember, you don't. But the law, I honestly, you do have to pay interest on it, I believe, based on the statutory interest rate that's found somewhere. But for the longest time, that interest rate has been 0. So I honestly can't remember if there is something that requires it to be in a separate account. But practically speaking, I've never seen any landlord get in any trouble for keeping it in their operating account. And since I've been practicing here in Roanoke, no interest has been due on any of these funds.
My experience has usually been that unless the landlord is excessively generous, they usually find something to deduct, and that's how they get out of paying the interest. Is they say, well, you know, your deposit was $1,200 and I owe you $47 in interest, but I'm also taking $247 so for cleaning the carpet, and here's $1,000 back, or if you're lucky. By the way, I wasn't laughing at you, James. I was laughing at a comment about somebody saying that said that they recognized the reference to Andy Griffith back in my presentation. So when I talked about Ben Weaver, if you did not know who Ben Weaver was, he's a character from the Andy Griffith show.